Unpaid interns are not real employees, according to a federal judge in New York. If being an unpaid intern wasn't bad enough for many of us out there, now a federal judge tells us that individuals who do not get paid do not get the protections of the New York City human rights laws, and therefore cannot bring up sexual harassment suits against their employers. Excuse me. So this all comes down to a case in which Judge Castle of the U.S. District Court in the Southern District of New York ruled last week that Miss Wong, who was an intern who felt as though that she was sexually assaulted or sexually harassed by her boss, she's an unpaid intern, like I said, did not qualify for protections under the 1964 Civil Rights Act nor the human rights law that protects the city of New York. And the reason why, he said, is because of the absence of payment, because she was not getting paid, meaning essentially there is not a clear employer-employee relationship which will allow her for the protections that exist under the human rights law as well as the 1964 Civil Rights Act. So I get the legality. So don't get me wrong. The legality makes sense, right? She's not part of a class. She doesn't opt in because of the employee-employer relationship, which requires a transfer of goods or services. You understand what I'm saying? But to that extent, I beg to differ on this judge's opinion. I understand why he made it, but I beg to differ, and here's why. So even legally, money is not the only thing that can define an employer-employee relationship, right? Just think about it for a second. So somebody could come and work. How about if somebody worked for food? Is that considered a remittance of payment because you're giving them a good? Or how about you have somebody who they're the super at your building and you don't pay them, but you give them, they have free rent, which is a good, right? It's a commodity. It's an exchange of a good that has a cash value. So if you can put a cash value on the internship program that you're offering, whether it be learn skills, whether it be you put a value on it based upon classroom seating hours or credits, which credits come at a cost, right? Because I went to GW, a credit's what, $1,200? Then she should qualify. Now I'm not a lawyer, but this is how I would argue it. She should then be in a situation where she is getting some sort of payment, and there is a clear employer-employee relationship, because she's learning, and learning costs, as we know. Sending your child to a public school costs you $17,000. It would cost the city that much or the state that much, and thus that is a transfer of goods that indeed have a cash value. And if it has a cash value, it can be considered salary. Or it can be considered a payment. While it's not, you can't write off on your taxes, or you can't claim it on your taxes as salary. It still has an associated cash value. It's a good. It's a commodity. So, with that being said, I believe as though she should be able to file her sexual assault complaint or sexual abuse complaint against this company. But don't worry. I mean, the name of the company is Phoenix. It's a Chinese language media company who denies that there was any discriminatory activity. But either way, I think that Ms. Wang has a case. Well, I think she should appeal this case all of the Supreme Court and let them deal with this unpaid internship stuff.